Hi, so if you're watching this video, it means that you're interested in immigration options for somebody that has high skills or high abilities in their particular field, and you're wondering about different immigration options to come to the United States. Well, that's wonderful because in this video, I'm going to talk about a number of different options for you to potentially come to the United States based on having a high degree of skill or an exceptional ability or an extraordinary ability in your particular field. So let's get started. As a quick overview, my name is Michael Ashoori, and I'm a U.S. immigration lawyer based in Los Angeles, California. At my law firm, we work with clients from all 50 states and worldwide. So again, let's get started. Let's get into these visa options and green card options for people that have high abilities or high skills in their particular field. Now, to start off, I want to talk about the EB-1A green card option. EB-1A is for people that have an extraordinary ability in a particular field. So let's say that you have an extraordinary ability in science or math, or if you have an extraordinary ability in a particular sport or business. Well, if you do, then you could potentially qualify for a green card through EB-1A. And the benefit of EB-1A is that it allows you to apply for your green card on your own through self-petition, without the need of an employer sponsoring you, without the need for a job offer, without the need for a family member sponsoring you. It allows you to apply for a green card on your own through self-petition. So as you can see, this is a tremendous option to come to the United States to get lawful permanent residence to the United States. So you might be wondering, how do I know if I qualify as somebody that has an extraordinary ability? How does USCIS determine whether somebody has an extraordinary ability? Well, the way they do this is that they have a number of different criteria. And in order to qualify as somebody with an extraordinary ability, you have to satisfy at least 3 of those different criteria. So one of the categories is to show that you've won prizes or awards that are either nationally or internationally recognized in your particular field. Another criteria is to show that you're a member in an association or organization that requires outstanding achievement in your field to be a member of that organization or association. Another criteria is to show that you have published material about you, such as press releases relating to your field. Another criteria is to show that you have publications that you have authored that have to do with your particular field of extraordinary ability. Another criteria is to show that you have high compensation compared to others in your field. And basically, what USCIS will do is they will go through a 2-part process to determine whether you have an extraordinary ability. First, they will review all of the evidence that you submit to them to determine whether you meet the evidentiary threshold. Basically, what this means is they're going to review your evidence to see whether you satisfy 3 of those different criteria. Then the case is going to move to step 2. Step 2 is referred to as the final merits determination. And during this stage, USCIS will evaluate your case as a whole. They will evaluate the totality of the evidence that you've provided to them to determine whether you are one of the few that has risen to the top of your field. And again, this is referred to as the final merits determination. And this is basically a big picture overview of how the EB-1A process works. So the next option that I want to talk to you about is called the EB-2 National Interest Waiver. The National Interest Waiver is specifically for people that would be coming to the United States and their work in the United States would be in the national interest. Think about a cancer researcher or a particular scientist that's coming to the United States to develop a cure for a certain type of a disease. That just gives you a general idea of somebody that would be coming to the United States whose work in the United States would be in the national interest. So with that general overview, I want to tell you one of the benefits of the National Interest Waiver. One of the major benefits of the National Interest Waiver is that similar to EB-1A, the EB-2 National Interest Waiver does not require an employer to sponsor you. It allows somebody to apply for their green card on their own through self-petition without the need for a job offer or a company sponsorship. And that is a tremendous benefit of the EB-2 National Interest Waiver. So now with that additional overview, let's go into some of the requirements. In order to qualify for an EB-2 national interest waiver, you must first meet the requirements for the EB-2 immigrant classification. You must also show that the work that you plan to do in the United States has substantial merit and national importance. Additionally, you must be well positioned to advance whatever it is that you're proposing to do in the United States. And lastly, you must show that it is in the national interest to waive the requirements for you to have a job offer from a U.S. employer and for that U.S. employer to go through the labor certification process to show that they were unable to hire a qualified U.S. worker. Again, you must show that it is in the national interest to waive those requirements. Now, the third option that I want to talk to you about is the O1 visa. The O1 visa is for people that have an extraordinary ability in a particular field. Now, this option is quite similar to the EB1A option that we discussed earlier. However, the O1 is a non-immigrant visa, meaning that it is not an option that directly leads to a green card. It's temporary. And again, for O1, you basically must show that you have an extraordinary ability in a particular field, such as having an extraordinary ability in math or science or a particular sport or in business. And similar to the EB1A, the way that you demonstrate that you have an extraordinary ability is by showing that you satisfy at least 3 of those different criteria, such as evidence that you've received prizes or awards, or that you've judged the works of others, or that you're a member in an association that requires outstanding achievement to be a member of that association, or that you receive a high salary or high compensation compared to others in your field. So again, you have to satisfy 3 of those requirements. Now, a couple of differences of the O1 compared to EB1A is that the O1 requires that you have an agent or a U.S. employer to file the petition on your behalf. So again, EB1A is eligible for self-petition, meaning that you can apply for the EB1A on your own without the need for any sort of a sponsor. However, O1 is different. With O1, you are required to either have an agent or an employer to file the immigration petition on your behalf. And again, the O1 is a non-immigrant option, whereas the EB1A is a green card option. And another thing that I want to mention is that the O1 generally has a lower threshold to get approved compared to EB1A. While there are similarities between how you prove that you have an extraordinary ability, the threshold to get approved for an O1 is lower than it is for EB1A. So there you have it. In this video, we did a general overview on 3 separate options for people to qualify for either a visa or a green card based on having an extraordinary ability, a high degree of skill in their particular field, or whether they are doing work in the United States that's in the national interest. I hope you guys learned a lot from this video. As always, thank you so much for tuning in, and I will see you on the next video.